The 5-year-old Insolvency and Bankruptcy Code, which deals with corporate defaulter, is often criticized for bad implementation, too many amendments, and also a very low recovery for banks. Some experts are even writing the obituary of the path-breaking law, which is modeled on the lines of Chapter 11 in US and UK Insolvency Act. Is it fair to criticize a new law on a single parameter, which is the low recovery rate for lending banks? Is 5 years a good enough time period to pass a judgment on a code that is taking on the high and mighty who always got a preferred treatment in evergreening their bad loans? What are the new reforms needed to make the IBC a more effective tool for bad loan resolution? Let's study its success and the failures, the justification for low recovery rate, and also the need to plug the gaps. First, the big picture. IBC has emerged as the most desirable route for lenders for a time-bound recovery. In the past 5 years, more than 4,300 defaulters were taken to the IBC by lenders as well as operational creditors. According to a RBI study, banks have recovered almost half the amount in 1920, which is the highest as compared to other recovery modes like Lok Adalats, DRTs and the SARFAESI Act. Supreme Court has also settled many of the interpretation in the Act which were challenged by defaulters and bidders. Take, for instance, the highest court has allowed lenders to initiate proceeding against personal guarantors of a defaulter, which is a very big setback for defaulting promoters. The single biggest criticism of the IBC is the low realization for financial creditor. The reason of low recovery rate figure of 13% in the last 5 years is a combination of many things. But it is also true that the banks were initially forced to take defaulting companies to IBC by the regulator RBI. Many banks were not even prepared then. Most of the cases that came in the first phase or the initial phase of IBC were the defaulters with unsustainable debt. These companies in steel, real estate, construction, power and other infra sectors were over-leveraged and were facing a challenging economic environment. There was a case of overcapacity in many sectors with demand just not there. As a result, there was not much investors' interest. Many strategic and financial investors didn't participate in bidding. They were watching from the fences as they feared litigation from stakeholders, frauds and fund diversion in default companies. The performance of the code in the initial year was also under watch as global distressed fund investors fear amendments in the Act because of various interested groups. The second big criticism is that the new bankruptcy code has become a place of liquidation than resolution. It is true that most of the cases under IBC have ended in liquidation, which means selling the assets of the company as a junk. But the higher liquidation was also because the banks transferred most of their bad stocks, including written-off cases to IBC in the first 5 years. Many of these defaulting cases were languishing in DRTs or the other courts for years. Without a court-driven bankruptcy mechanism, the bankers had earlier feared investigation from CBI, CVC and the CAG if they take a call to dispose of the bad loan. Under the IBC, which was a court-driven process, they were comfortable in taking massive haircuts in written-off bad loans. The bankruptcy code has also got a hammering for breaching the set timelines of 180 days and a maximum of 270 days to resolve a bad loan. More than 80% of the admitted cases have overshot the 270 days deadline for the resolution. But a deadline breach was expected as the law was new and there were many challenges because of non-cooperation by defaulters and also litigations. The infrastructure of insolvency professionals or the IRP was also new, and for the first time in the history of Indian corporate, the promoters were kicked out of the defaulting companies. Imagine getting raw material supplies from vendors when everyone knows the company is bankrupt. Things are certainly better now for bankers and IRPs as many of the controversial issues or interpretations are settled by various courts. There is also a new deadline of 330 days, which is more realistic given the counter bids and the practical difficulties in resolving complex cases. The higher default cases also flooded the court because of operational creditor utilizing the court for getting their money back. In many cases, there were disputed claims. Operational creditors are vendors and suppliers of goods and services. Employees and factory workers are also part of operational creditors. Part of the reason for higher number of cases was the lower threshold of rupees 1 lakh for invoking the bankruptcy court. Operational creditor and also employees invoked IBC more aggressively for dues of few lakhs to arm twist the promoters. The threshold limit for invoking IBC has now been changed to rupees 1 crore post the outbreak of the pandemic. The limited cases going forward will also address the capacity issue, as many complained earlier that there were limited NCLT and the appellate authority to deal with the IBC cases. The biggest change is probably the behavior of the defaulter. The change of ownership in SR Steel, Bhushan Steel, Alok Industry and Monat Spark has shown that the days of evergreening of loans are gone. Defaulters are now also coming around, talking and willing to settle or take calls on selling assets and bring additional equity to pay back interest and other obligations. The banks have actually managed to recover a reasonable value in a much faster time as in the case of earlier system. The time value of money kicks in as bankers quickly redeploy the recovered money in fresh loans earning 10 to 15% interest per annum. This is much better than realizing the same money or even less after 5 to 10 years of fighting the case in DRTs with manpower and legal cost, and also asset losing its productive value. IBC certainly need more reforms like any other new law. There are gaps that needed to be filled on a regular basis. Take for instance the Section 12A, which allows for withdrawal of bankruptcy application by lenders in situation where the company has to be taken into liquidation under IBC in the absence of bids, needs a relook. Defaulting promoters are making a backdoor entry by offering a one-time settlement to banks by paying a slightly higher amount than the liquidation value. Allowing defaulting promoters to come back is not justified. That's a big loophole. In terms of the infrastructure, there is clearly a need for specialized benches and also putting judges with exposure in handling complex corporate cases. The coming 5 years of IBC will be crucial as the next batch of fresh NPAs post-COVID will test the effectiveness of the bankruptcy court.